So I have heard horror stories about associations building projects. They could be something related to sidewalks, or it could be like a walkway over a stream. And they realized they did not have the proper permits.
Yeah, it's a scenario we run across quite a bit. Basically, something that, if you do a little bit of foresight looking, ahead, you could avoid it. But if you don't, obviously, there's a lot of price to pay in that aspect.
These things can literally turn into disasters.
Yeah, there are absolutely a lot of fines that go along with that, and there are occasions where they will make a person take out whatever improvement they had already started.
What is a permit?
A permit is generally permission to carry out an act that is regulated in some way through some building code or through some environmental issue or code or law that's in effect. And those are generally put into place in order to control and make sure that whatever facility is being built or constructed is being done in accordance with safe regulations and safe practice to make sure that there's no problems with it down the line.
How does an association even know that they need a permit? And if they did need a permit, who's responsible?
That's the tricky part. You really don't know unless you have a professional look at it. You need an engineer really evaluate that. The responsibility lies with the owner. There is no ability to say, no, I wasn't aware of it. They really don't want to hear that. The only way for them to really regulate, to put the onus on the owner of the property.
I had heard a horror story, and maybe you were the individual that even maybe told me about it, where an association had put a walkway over a stream. It seemed simple enough. It wasn't a huge project, but there were some pretty serious ramifications involved because they didn't have the proper permits.
Yeah, that was me that did talk about that. And actually, it was not an association. It was a municipality. So, just to show when it comes to the state mandated type of activities, no one is safe. If you do something wrong, they're going to come after you. And in this particular case, the entity decided they had a park, and there was a little stream. They didn't think much of it. It was a couple of feet wide, and they said, boy, it'd really be a good idea to put a nice little footbridge across this. Now, the problem that you have in this case is that was a regulated area that was under control of the DEP floodplain management program. And basically, their criteria is anything that drains over 50 acres of land into it is now regulated. So what happened was, at that particular point in time, that being a regulated area, they needed to get a permit from the DEP in order to do this. The DEP found out about it. They were not happy, to say the least. They did make them take it out, and I think it resulted in several $100,000 worth of fines when it was all said and done. And once it gets to the DEP level, these things are very strictly mandated. They don't even have the flexibility to give you a break, so to speak. Many of them don't want to.
So if you're a manager or a board, necessarily calling the town and getting a permit from them doesn't really protect you 100%, because theoretically you may need a permit from another governmental agency.
Correct. A lot of them overlap, and we see that the DEP has several different factions. Another story, a project that we had where it was a lake requirement for floodplain situation or permit, and there was also wetlands involved. In this particular case, this lake was also considered a dam, so dam safety needed to be involved. We went ahead and got our permits from the DEP. Well, in this case, we got our floodplain, we got our wetlands. I started looking through the paperwork and said, wait a minute, where is the dam safety permit? And then they said, oh, you know what? We forgot to do that. Had we gone forward and, initiated the project without having that permit, we would have been in violation.
It doesn't seem like a manager or a board is even going to know if they got all the right permits, because they can call the town can give them a permit. And as far as the town's done, that's their only concern, right? They're not responsible to educate you on what other permits you need.
Yeah, absolutely not. It's your responsibility by every law and program that's put into effect. You can't go back to them even if they make that mistake. And there's a lot of areas that overlap, and there's a lot of areas that are really not even evidence you wouldn't think was anything to be concerned with, but may in fact be a buffer for a wetlands on a property next door, which you're still responsible to respect and operate in accordance with those laws.
There's really no way a manager or a board is really going to know 100% that they got all the proper permits.
Yes, I would agree with that 100%.
And what can some of the ramifications be?
Well, the ramifications are generally big fines associated. There's a lot of legal fees, trouble. There could be criminal prosecution in some cases. And also back is they will, in cases, make you remove the facility, even if it was done in accordance with what you think was right. If they didn't get a chance to inspect it, in some area, they'll make you take it up and get the permit and do it over again if need be.
So are there any other common items that associations start work on where they need a permit, but it wasn't obvious that they would really indeed need one?
There could be a case where if the association had public roadways, if you were doing any kind of work in that roadway, you would need a permit from whether it would be a municipality that owned the road, or in some cases the county, or obviously the state if it was a highway. Another one that kind of slips through the cracks are a soil erosion permit, where any activity over 5,000 square feet is going to require a soil erosion permit to make sure that you don't have any erosion. 5,000 square foot basically adds up pretty quickly when you're doing a new parking lot, or even if you're doing a sidewalk replacement, for example. Another one that we see, like we said, is the perimeters of the sites, especially where there's storm drainage facilities. They're going to fall into regulated activities relative to possible wetlands. Currently working on a site right now where they have a stormwater basin that was supposed to be a dry detention basin. Over the years got blocked up. It's basically gotten to a point where now you have a lot of wetlands type plants growing in the bottom because it became, mucked up and wet over the years because of poor drainage. And technically, they're, in order to just do maintenance, in some cases, you're going to get a permit from the DEP. These are things that basically happened over a period of time by just not maintaining the area.
It seems to me like the DEP is not someone you want to have in your life.
No, they're not easy to deal with, even in just a regulatory method, but they get even more onerous when something that they believe is within their domain is. Another thing that we found with the DEP is, believe it or not, you could innocently go in and try to, if you had a stream on your property, floodplain areas, and just remove trees that may have fallen down. That's not allowed because theoretically those trees that block the water are holding back water for downstream properties. And there's been cases where, the person that actually, with all good intentions tried to clear the stream out, got in trouble because now it caused damage to the people downstream.
So it seems to me if you're anywhere near water or wetlands, and you may not even realize that you are, that could be one of your biggest issues or turn into one of your most expensive problems, correct?
Absolutely. Anytime you have pure ground, pure land that hasn't been developed yet and it's still treed, it's really imperative that you look at that. Maybe taking a few trees out to do a tot lot or something like that. Next thing you know, you're in some hot water.
What's the scenario for, is there like a statute of limitations on these kind of incidents? Because I assume there's absolutely plenty of structures out there over the years that have been built without permits that may be discovered later.
I don't know that there's one. I've never been involved with a situation where they've built that way. Sometimes they'll retroactively go in after the rules have changed, and you have to argue the case against it to say that there's something that should stay there that wasn't. But basically, it's usually timed with the onset of the law.
And then how about the documentation that's all involved? Who should be responsible for holding on to that and saving that? If an association hires an industry professional like yourself, is it going to be you? Or should the association still expect to have copies on file?
Well, we have a requirement through just our businesses to keep things for 7 years, but it's always a good idea to get copies of all those plans, permits that go along with that, and keep them with the association. And one of the things that we also recommend now is that they do electronically.
Are permits expensive?
Generally, they are, yeah. For example, it's usually a function of the size of the project itself. But you could be talking about, several $1,000s for a small soil erosion permit just for the fee itself.
Now, I'm not going to put you on the spot because you're not an attorney, but is this a case when you deal with a governmental agency that you're guilty until you prove yourself innocent?
Absolutely. I mean, all those cases that I spoke to you about, as far as the examples, they resulted in attorneys becoming involved, trying to sort the puzzle out, so to speak. And obviously that, is another fee that gets incurred, down the line.
So what haven't I asked you to wrap up?
I would say, just as an overview, some of the projects that you want to be, aware of, that you're looking at, anything that you're doing on your grounds, even if it looks like just repair, have somebody take a look and understand what it may be. If you're putting a new parking, let's say you're expanding parking in your facility, you may now need to also take a look at the local zoning. You may need to go to the planning board to get that taken care of, because a lot of these projects were built at very tight tolerances and right up to the limit of impervious covers. Many of the towns now are requiring additional storm drainage facilities to be implemented and put into in conjunction with those types of things.
If an association needs to go to the planning board, that would be something if they had hired an industry professional like yourself, you would handle, correct?
Yeah, basically what would happen is that you would present a set of plans. They would go to the town for review to the planning board professionals. Then be a public hearing where you would have to go and present the case. And that's a combination of an attorney because it's a legal entity, but the engineer would also do the outline of the testimony regarding what the project actually consisted of. And then anybody within 200 feet gets notice of it, and anybody else is still available to attend. And you have those crazy meetings where there's a lot of outcry. And some of this, as crazy as it may seem, some of the problems that we've seen come up are actually as a result of the residents of the project in and of itself, because they don't understand the process or why it's happening.
It seems like this is a tough one though for managers and board members though, Chuck, because I can see like a contractor coming up to them, and I don't like to bunch the contractors into one category, right? Because there's all different kinds of contractors, and some of them are awesome and some of them are not. So I could see definitely a contractor coming up to a manager or board member and saying, look, I'm going to get all the proper permits for this, don't worry about it. As an engineer, how do you feel about those kind of statements, and how should an association look at them?
They're usually well-intended, but they're usually very dangerous. A lot of times contractors are there to construct things. They rely on plans that are given to them to do so. Sometimes they've seen enough of the plans where they think, the same situation, but every situation, believe it or not, is different. Even though a contractor has good intentions and he wants to, move along and thinks that could happen, there's a lot of times where he's just not familiar with that particular area. And, even from town to town, the permits may vary as to what they want and don't want. Once again, the contractor is not going to be the guy to bear the brunt. It's always the owner who is ultimately responsible for whatever actions take place on their property.
So are your final words of wisdom something around the fact that this is definitely a scenario where you could get yourself in trouble and not even realize it?
Absolutely. I mean, there's times, and we are very diligent in our business of, scouring the land, so to speak, to find out the new regulations that come into effect. Things change so often that even if you thought you had it covered, if it wasn't what your primary focus was as a professional, you wouldn't be able to keep track of it. You may have had something happen 3 months before, and your next project is already outdated. And there's different permits that are necessary for those.
Well, thanks so much, Chuck.
Thank you.